Sir, we are live. It's on your video. Sir, you're requested to switch on your video. Sir, can you hear me?
Yes, I can hear you.
Sir, please switch on your video.
Yeah, sure. Will do. Visible?
Yes, sir, you are visible. Over to Chinu.
Very warm welcome, sir. So with your permission, I would like to start the session.
Sure.
Good evening, everyone. I, on behalf of Team Legal Expatriate, welcome you all on the first day of our 7-day online course on corporate litigation, drafting and pleading. It's an honor to introduce our distinguished guest speaker for today's session, Mr. Harshul Shah, a dynamic advocate, solicitor, and accomplished insolvency professional who brings a wealth of experience and expertise to this platform. As a founder of corporate legal practice, Mr. Harshul's focus lies on non-litigation corporate matters, particularly excelling in drafting and negotiating contracts, corporate laws, and capital matters. With over 15 years of experience in legal field, he has worked with top-tier law firms, including Gagrat & Co. and Wadia, Gandhi & Co. Based in Mumbai, his comprehensive experience extends to intricate investment transactions such as joint ventures, private equity funding, IPOs, M&A, and due diligences. Mr. Harshul's unique specialization lies in drafting and negotiating commercial contracts, alongside his expertise in matters related to the insolvency and bankruptcy code. Prior to founding corporate legal practice, he contributed to the merchant banking team of Wadi Gandhi & Co. His profound understanding of IBC matters is evidenced by his role in handling CIRPs of prominent companies and acting as a consultant for IPs. With extensive sectoral expertise spanning banking, IT, telecom, and manufacturing, Mr. Harshul is a sought-after speaker. He has shared his insights and engagements organized by the prestigious institutions like the Institute of Company Secretaries of India and the Bar Council of Maharashtra and Goa. His journey is fortified by his involvement in significant projects ranging from joint ventures to due diligence and acquisitions of banks and companies. His dedication and excellence is underscored by his role as an insolvency professional and his role in pivotal CRIPs. I beg your pardon. It's CIPRs. I beg your pardon. It's CIRPs, reflects his expertise. Today, we are fortunate to tap into Mr. Harshul Shah's wealth of knowledge and experience. Please join me welcoming him on to this session as we are eagerly anticipate in the insights he'll share with us today. Now, before handing over the session to our speaker, I request all you to keep your mic and camera off so that it would not create any hindrance during the ongoing session. Over to you, sir.
Thank you very much, Akanksha. Thanks for the extensive introduction that you gave me and the wonderful platform you gave me for sharing my thoughts. I hope I'm audible and visible to everyone.
Yes, you are perfectly audible and visible, sir.
Just give me a minute. I'll start a session. I'll share the screen. I'll start the session. Is the screen visible now?
Yes, sir, it is visible, but it's not still not the
loading.
PPT.
It's loading, right?
Yeah.
Is it visible?
The PPT is not visible, sir. It's just your folder.
It's only folder which is visible.
Yes, sir. It is visible now, sir.
It's visible?
Yes, sir.
Wonderful. So, a warm welcome to all the participants. Just to give the basic background, she has given Akanksha has given extensive background and introduction about me. Just to add to that, so far as insolvency matters are concerned, I am very much into NCLT and handle many NCLT litigations. So we draft many NCLT applications and interlocutory applications, the original petitions and all those things. So I am going to share my experiences relating to that today. So just to share with it, we'll start with a very basic introduction about how these proceedings are to be done and where these NCLT proceedings are to be made. So if I go through the very basic, starting from how this NCLT was established and what are the relevant regulations, I think that will help you to understand the basics about the NCLT litigations and NCLT regulations that is in place. The NCLT was established sometime in 1st June 2016 with the objective to club the matters related to the companies all under one roof. This time when I thought of
Sir, we are not able to hear you. Sir,
audible, visible.
yes, sir. Yes, sir. You are audible and
I
visible.
think there was an interruption in between. Okay. I hope the screen is visible.
Yes, sir. It is visible.
Okay. So just to restart again, instead of continuing, I'll restart because I don't know, somewhere there was interruption. So sometime in 2016, when this law was introduced of the IBC and the NCLT was introduced, NCLT was established 2016 June. Law was introduced sometime in 2016 and December 2016. That was the time when we were inclined about the insolvency and bankruptcy code. A lot of talks were going on about the discussion paper, about the insolvency change in the insolvency law. Since I was qualified company secretary and also advocate and solicitor, I was practicing as a corporate lawyer since almost 15 years. I was very much inclined towards this particular law. And I thought of passing the exam of insolvency professional. That was the time when we looked into this aspect of IBC. And so it was when I take you through those era, people were not sure about what this IBC law is all about or insolvency law, how it will be implemented. A lot of things were going on in the mind about how NCLT will deal with the insolvency proceedings, which was otherwise the powers vested then in the High Court. So all the powers of the relating to the company would be given to the NCLT. So The whole objective while this NCLT was established in 2016 was to club the matters related to company laws under one roof. Apart from company matters, under the Companies Act 2016, 2013, the NCLT jurisdiction has also been handed over to the NCLT. So all the insolvency relating to the companies and LLP was given to the NCLT. Now, where this jurisdiction lies under IBC, it is section 60 of the IBC, which says that adjudicating authority for the corporate person, adjudicating authority means NCLT, NCLT when it goes to the appellate tribunal, and when it goes to the further appeal, it's a Supreme Court. All these three judiciary are considered as adjudicating authority so far as the IBC is concerned. So, how this application is to be filed, where it is filed. So let's try and understand that. The adjudicating authority in relation to insolvency resolution and liquidation for corporate person, including corporate debtors, CD, and personal guarantor thereof, shall be NCLT, having territorial jurisdiction over the place where the registered office of the corporate person is located. So first provision of section 60, which says that where you file this application, first of all, it is required to be filed in insolvency or any proceedings relating to the personal guarantor in the insolvency proceedings is required to be filed before the NCLT. Where in NCLT, where the territorial jurisdiction will lie, it will lie at the place where the registered of the corporate person is located. Without prejudice to subsection 1 and notwithstanding anything contrary contained in this code, where the corporate insolvency resolution process, now I will consider this as a CIRP, it is a very common name which is used in IBC for IBC proceedings, CIRP, that is corporate insolvency resolution process, or liquidation proceedings of the corporate debtor, CD, is pending before an NCLT. Application relating to CIRP, liquidation, bankruptcy of the guarantor, as the case may be, of such CD shall be filed before such NCLT. So wherever in whichever NCLT this proceedings was filed against the corporate debtor, any proceedings which is relating to that, which is relating to the CIRP or relating to the liquidation or relating to its personal guarantor, that is bankruptcy of the guarantors, personal guarantor or corporate guarantors, it is required to be filed in the same NCLT in which these proceedings were filed. So jurisdiction lies accordingly. CIRP, liquidation or bankruptcy proceedings of the corporate guarantor or personal guarantor, as the case may be of the corporate debtor, pending in the court or tribunal shall stand transferred to the adjudicating authority dealing with the CIRP liquidation proceeding of such CD. So at the time when this law was incorporated, if any proceedings are pending before any other court, for example, that time the insolvency or winding up proceedings against the company was required to be filed in the High Court. So all those proceedings shall also get transferred to this NCLT where the CIRP or liquidation proceedings against the corporate debtor is filed. The NCLT shall be vested with all the powers of the TRD as contemplated under Part 3 of the Code for the purpose of subsection 2. Now, what is Part 3 of the Code is dealing basically with the personal guarantors and those kind of individual insolvencies. So individual insolvencies, though it's still to be implemented properly, but so far as personal guarantors are concerned, their powers are already there. You can already it is already implemented, and therefore proceedings against the personal guarantors or corporate guarantors can be filed in the same NCLT in which the proceedings against the corporate debtor is filed. So therefore, the powers which is then required from the DRT shall be deemed to have been vested in the NCLT for that purposes. Now, subsection 5, this is one of the most important subsections where most of the interlocutory applications will find. Notwithstanding, it is very important to understand this section. Notwithstanding anything to the contrary contained in any other law for the time being in force, the NCLT shall have jurisdiction to entertain or dispose of what kind of powers NCLT have. Any application or proceedings by or against the corporate debtor or corporate person. You say, sir, what is the difference between corporate debtor and a corporate person? Corporate debtor basically is when it comes to section 7 application, section 9 application, etc., where there is a default and proceedings are filed for the corporate insolvency resolution process, CIRP, you use the word corporate debtor, where the corporate person essentially is also a company. A company, which if it is a debtor, then it's a corporate debtor. Otherwise, it's a, for example, we go to the voluntary winding up, you'll see the word corporate person. It's one and the same thing.
Sorry
Essentially
to
speaking, the
interrupt.
company, corporate
Excuse me,
debtor.
sir.
Yes.
Sorry to
Yes.
interrupt. Actually, the voice is, I guess the participants are having some issue with the voice. They are asking you to go a bit slower for the same. So they may be
Okay.
able to understand properly. Yes, sir.
Sure. Shall do so. So, what kind of application or proceedings which is filed by or against the corporate debtor? That any application against the corporate debtor can be filed in the NCLT. Second, any claim made by or against the corporate debtor or a corporate person, including claims by or against any of the subsidiaries situated in India, that can also be filed in the NCLT. So once you file the CIRP against the corporate debtor, against any company, in that situation, all the proceedings which are peripheral to that, ancillary to that, relating to that, shall be filed in the same NCLT before whom the CIRP proceedings have been filed or has been initiated. The same NCLT shall have jurisdiction also to entertain further proceedings relating to the liquidation, personal guarantors, corporate guarantors, all those proceedings relating to that insolvency. That is what it says. And thirdly, any question of priorities or any question of law facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor or the corporate person under this code. This is very important section. Many interlocutory applications are filed in this subclause. That is, any question of priorities. What is question of priorities? Who will be paid in priority of the other? For example, if you go to the IBC law, where under section 53, the priorities of payments are given. How it was given in the previous, you see the Companies Act also, there is a, when the company goes into winding up, there are certain priorities of payment. For example, secured creditor will be paid first in priority to other. That kind of priority, which is given even under section 53 of the code, where CIRP cost will be on the top priority. Thereafter, the secured creditor along with the employees dues. So all those priorities, if there is any question of law which is to be determined about the priorities of payments, that question shall be determined by the NCLT. Similarly, any question of law or of the facts, that shall also be determined by the NCLT. So most of the interlocutory application you will see is fall within this section, that is section 60, subsection 5, clause C. Okay. So anything which is coming out or emerging out of the CIRP or out of the liquidation process against the corporate debtor or against any IRP or liquidator, it is required to be filed before the same NCLT against whom the within which the CIRP has been initiated. It is also very pertinent to note section 63 when we read section 60. It is also pertinent to note section 63, which says that civil court not to have jurisdiction means no civil court or authority shall have jurisdiction to entertain any suit or proceedings in respect of any matter on which the NCLT or NCLAT has jurisdiction under this code. So when it comes to the any matter relating to the company or corporate, then this particular NCLT shall have jurisdiction to deal with those proceedings, and no other civil court or authority shall have any jurisdiction or to entertain such proceedings. Now, what kind of application is required to be filed? If we go through under IBC, there are essentially many various types of application which may be filed by an applicant. But if you see about the CIRP, there are essentially three applicants. One is a financial creditor who can file the application. They can file either individually or jointly the application for initiating corporate insolvency resolution process against the corporate debtor. Second is operational creditors who can file it individually against the corporate debtor. Operational creditor cannot jointly file any application. At the same time, the company itself may file the application, what we call it as corporate applicant. Application by the financial creditor can be filed under section 7. Operational creditor can be filed under section 9. And corporate debtor or the corporate applicant can be filed under section 10 itself. Who are the financial creditors? Financial creditors are basically the bankers, financial institution, any creditor of the guarantee. They are all financial creditors who lend the money to the company. Operational creditors are basically those who are into day-to-day operations. If they are the creditor, for example, you supply the goods, or those who supply the goods or services. And any tax which the corporate debtor is required to be paid to the government. So the government, state government, central government, whom the tax are required to be paid pursuant to the goods or services supplied. So all those things will be covered under the operational creditor. Similarly, the employees of the company, workmen of the company, they will also be covered as an operational creditor. So they can file the application. Now, for filing this application, what are the basic criteria? On what basis this application will be tested or decided? When you go to the NCLT, on what basis NCLT will decide whether this application is tenable? What are the criteria? The criteria are, first, there should be a debt which should be undisputed and ascertained. This is very important. You cannot claim merely, for example, if you are having a claim about the damages, which is not established or unsubstantiated, you cannot simply file the application before the NCLT because it is not ascertained, it is not determined by any civil court. So, a debt should be ascertained and undisputed. Second, there should be a default of such debt. That default should be of at least 1 crore rupees or more. As on date, when this IBC was introduced, the threshold was 1 lakh rupees, but now it is 1 crore rupees. So there should be a debt, plus there should be a default, plus the application should be complete in all respect. Now, what is complete in all respect? It means there are certain criteria given in the law. We'll discuss that in the next slide. That certain supporting documents are also required to be attached. Certain documents are to be proved. And like, for example, if you are claiming a debt and default, you have to prove that debt and default. All the supporting documents should be part of it. Similarly, you have to propose or recommend the name of the IRP. So all these things is a part of the application. If the application is incomplete in all this respect or any of these respect, then it is a ground for rejection. So therefore, your application should be complete in all respect. We'll discuss in detail how it should be complete in all respect. Fourth, no disciplinary proceedings against the proposed IRP. Now, when any of these people, financial creditor, operational creditor, or corporate applicant, make an application, they have to recommend the name of the IRP. That is interim resolution professional. That is a qualified insolvency professional. They have to take the consent of the insolvency professional in Form 2, and they have to annex it along with the application that this insolvency professional is recommended for the carrying out CIRP process. Now, that the name which is recommended of that insolvency professional, there should be no disciplinary proceeding against the proposed IRP. Similarly, no fraudulent intention in making such application. So therefore, what is also important is that application should not have been filed with the intent to deceive someone or to make any fraudulent application, just to get rid of the liabilities or debt or to make some haircuts. So therefore, these are the 5 main criteria based on which the NCLT or the adjudicating authority will test your application. So there should be a debt, there should be a default, application should be complete in all respect, no disciplinary proceeding against the proposed IRP, and no fraudulent intention in making such application. These are the testing criteria based on which the application filed by the financial creditor or operational creditor or corporate applicant shall be tested. Apart from these 3 applications, which are filed by the financial creditor or operational creditor or corporate applicant for initiating the corporate insolvency resolution process, that is CIRP, many other application can also be filed by various stakeholders during the CIRP. Once the CIRP is filed, CIRP is admitted, and there is a commencement of the corporate insolvency resolution process, there may be few more interlocutory applications that is within this CIRP. Main application or the main petition is the CIRP. Within that, there may be various complications that may be emerging during the process of CIRP, and various applications may be required to be filed by various other stakeholders. So those applications are considered or named as interlocutory applications, and that applications are filed by various aggrieved parties of the stakeholders. So we'll discuss that more in detail. But before we move to the interlocutory applications or various applications that can be filed in this, let's try and understand, first of all, the three main applications which are envisaged and specifically given under the IBC. That is the application by financial creditor, by operational creditor, and by the corporate applicants. So how application is filed by the financial creditor? It is under section 7. So we'll discuss this, how application is filed. Financial creditor, FC, either itself or jointly with other financial creditors, or any other person on behalf of the financial creditor as notified by the central government. Now, what is that other person that is notified by the central government? The central government has notified on 27 February 2019 certain people who can file on behalf of the financial creditor. They are, in case the person is a minor, financial creditor is minor, then the guardian, or when the person dies, the executor or administrator of the estate of the financial creditor, or in case of debenture trust, the debenture trustee, they are the persons who can file on behalf of the financial creditor. And in case of the company, which is an artificial person, who generally file for the company, the board of directors of the company. So when you say board of directors of the company, not all the board of directors sign. Generally, board of directors authorize one or two of the board of directors to file this application by way of an authority letter or by way of a resolution. And therefore, whenever we file the application, we also have to attach the copy of the resolution of the company authorizing the director or the person to file the application on behalf of the board of directors of the company. Okay, so these are the people who can file the application for initiating the corporate insolvency resolution process against the corporate debtor before the NCLT when a default has occurred. Default means more than 1 crore rupees. The threshold is 1 crore. So when there is a default of more than 1 crore, then this application can be filed. A default includes a default in respect of the financial debt owed not only to the applicant financial creditor, but to any other financial creditor of the corporate debtor. As I said, it can be filed jointly. So it is not necessary that a financial creditor itself can file for itself. It can also file on behalf of the other financial creditors. For example, when there is a consortium arrangement, the lead bankers file application for all the financial creditors. Financial creditors shall make application in Form 1 with the fees of rupees 25,000 along with these documents. Okay, what I've done is I'll just briefly explain you, because if you see in the IBC Act or something, you will not find this text. There are 4 laws I've combined for you to understand it properly, what exactly is required to be filed. One is IBC, the Act, Section 7 of the Act. Along with that, you have to read the CIRP regulations, which also set out certain documents which are required to be annexed. In addition to that, you have to go through the IBBI adjudicating authority regulations. It says how that this application is required to be filed. In addition to that, you also have to go through the NCLT rules. So all these 4 laws I have combined and I have made an entire set of process how this application can be filed, so that in nutshell you can understand how this application is required to be filed by. Financial creditor shall make an application in Form 1. Form 1 of the IBBI adjudicating authority regulations. It is given. The format is given. You just have to fill up that form. It is very simple, not at all complicated. Okay. So I'll show you that form as well. Once we go through this process part, I'll show you the form so that you understand how form is required to be filled. You just have to fill up that form, and along with that, you have to give rupees 25,000 as the fees, which is NCLT fees for filing, along with these documents. So these are your exhibits. Which are the documents which you have to put up in the exhibits? The record of default with information utility, IU, or such other record, evidence of the default. So what it says that if you have the record of the IU. It means certified. And I hope you know what is information utility, NESL, where each banker registered their debt. And information utility certifies that this is a legitimate debt after verifying it with the corporate debtor. So the record of default, if it is provided from the information utility, or where if you not registered so far, now in fact NCLT is insisting that record from the information utility should be available, because now almost all the bankers and institutions are registering the record with the record of the debt with the information utility. So things are in place, and therefore now NCLT insists that record from information utility should suffice to prove the debt. However, if there is no such record, then evidence of the other default. What are the other evidences of the default? Such as financial contract. Financial contract in case of banks, what will be a financial contract? Loan agreement. So loan agreement, hypothecation, mortgage, all those documentation, lending documentation that is made, that will be the financial contract. Second, record evidencing the amount committed by the financial creditor to the corporate debtor under the facility has been drawn by the corporate debtor. It means secondly, you have to prove that the facilities or the loan which has been given by the bankers have been used by the corporate debtor. So that will be coming from the bank statement. Third is a financial statement, that is a bank statement showing the non-payment of the debt. Fourth, order of any court or tribunal, if any. The bank have anyway processed through some other source. Any financial creditor, if they have processed through some other source, maybe sometime arbitration, maybe sometime DRT, sometimes some other source, some other courts, and you have obtained the order of that court or tribunal, then that would also be sufficient, if any. Or where the applicant is an assignee or the transferee of the financial contract, a copy of the assignment deed or other relevant document to show the assignment. So that is, what is assignment? I hope you know what is a securitization. Many banks, once the account goes into NPA and they find that it's not recoverable, they securitize, they assign the debt to some other entity at a nominal valuation. They transfer the debt, and that is how, if in case there is an assignee of that debt, then they can also provide the deed of assignment to establish the debt component. So these are the documents which is given in the law that you have to attach it. Apart from that, if you see the regulation also, regulation 2A of the CIRP regulation, it says that record or evidence of the default by the financial creditor for the purpose of section 7(3)A of IBC, financial creditor may furnish any of the following record or evidence of default, namely certified copy of the entries in the relevant account of the banker's book as defined under section 2(3) of the Bankers Book Evidence Act. I hope you know the law about Bankers Book Evidence Act. There is a very small barrack. If you have not read, please read it. Very few sections are there. But then what the evidence is about the entries in the Bankers Book Evidence is very important. How it is taken into evidence in the court of law. So therefore, a certified copy of the relevant accounts of the bankers can be produced as an evidence, or an order of the court or tribunal that has adjudicated upon the non-payment of the debt where the period of appeal against such order has been expired. Means now no further appeal can be filed because the period for filing the appeal has expired and the order is already in favor of the bank to recover the dues, or there is a non-payment or default can be established. So these are the documents also. So when you read what documents should be annexed, you have to see the section of the act, you have to see the CIRP regulation. There also certain documents are mentioned. And then you have to read along with that the IBBI, this adjudicating authority, filing an application, regulations, where also the process is given, and you have to read it along with the NCLT rules. I have combined everything, and in a nutshell, I have given you what exactly is required to be done. Secondly, consent of the proposed IRP in Form 2. When you file application, the financial creditor has to also file the consent of the proposed interim resolution professional in Form 2 and any other information specified by IBBI, So what are those other information specified by IBPI? Either it is coming from the circular or it is coming from the CIRP regulations. CIRP regulation we already highlighted. So these things you have to attach along with the application in Form 1. Applicant shall serve a copy of the application to the registered office of the city and to the IBPI by RPAD or by speed post or by hand delivery or by electronic means. There are various means by which you can serve the application, and to whom it is required to be served. One, to the corporate debtor against whom you are filing the CIRP application, and the other is IBPI. IBPI has given the electronic portal also where you can upload it. So through a circular. So you can do it through that, but it is required to be done before filing the NCLT application. If you file the NCLT application without proof of service, it will have objection in the scrutiny stage itself. So you have to file this application. You have to serve this copy to the registered office of the corporate debtor as well as to the IBPI. NCLT shall within 14 days of receipt of the application ascertain existence of the default from the records of the IUs, or that is information utilities, or on the basis of the evidence furnished by the financial creditor. However, if the NCLT has not ascertained the existence of the default or passed any order as set out below, within such timeline, it shall record the reason in writing for the same. Okay. So where NCLT is satisfied that now how this order will be passed by the NCLT for initiating the corporate insolvency resolution process. That is, now until now there was a role of the applicant. What applicant have to annex, what applicant have to provide in the application, the law relating to that. Now the role of the NCLT once this application is filed. Where the NCLT is satisfied that a default has occurred. Secondly, the application is complete and there is no disciplinary proceeding pending against the proposed IRP. It may by order admit look into. First, there should be a debt plus default of 1 crore rupees. Secondly, application is complete in all respect. What is complete means? Whatever documents we have discussed, all these documents are properly annexed and it is evidence to understand the default, whether the default has occurred. Sometimes the other party may also challenge that, and court has to give the hearing to both the parties. If other party is disputing or denying the default, then court has to give that opportunity of being heard to the corporate debtor as well, on the principles of natural justice. So, after once the court is satisfied on these three aspects, the court will either admit the application. And if these three aspects are not properly satisfied, then it will reject the application after giving 7 days notice to rectify the defect. If they find there is an incomplete application or application needs to have certain more documents which are not there, NCLT will inform you by giving 7 days notice. And within that 7 days, you have to comply with and complete the application. So that comes at the stage of the objection when you file the application. So, and once it is admitted, the CIRP shall commence from the date of admission of the application. So your corporate insolvency resolution process shall commence from the date of admission of the application. That will be considered under IBC as the insolvency commencement date. NCLT shall communicate the order to the financial creditor and also to the corporate debtor if the application is admitted within 7 days of the admission or rejection of the application. Very interesting to note here that NCLT shall communicate this order to the financial creditor, that is means the applicant, and to the corporate debtor, means against whom this application is admitted. But NCLT is not going to communicate this to the IRP or the insolvency professional who is appointed. Insolvency professional are then considered as the officer of the court, and it is presumed that they would have seen the order uploaded on the court, and therefore NCLT is not communicating the order specifically to IR. Provided that, this becomes now very important, two provisions are added by amendment. Provided that for financial creditors referred to in clause A and B of section 21(6)(a), that is creditors of a class. When I am saying creditors of a class, I am here not talking about the home buyers, because that is in the second provision. Creditors of many other class, for example, deposit holders. If you see section 21(6)(a), you will understand we are talking about the persons who are authorized by someone. That is through an authorized representative. Maybe a deposit holder, maybe the debenture holders. They are also falling within the class when they are more than 10. So therefore, we are talking of that kind of people. An application for initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such creditors. Means 100 of such debenture holders or 100 of such deposit holders in the same class of the same category. That is either deposit holder or debenture holder, whichever class they are falling in. Or not less than 10% of the total number of such creditors in the class. So either 100 creditors or 10% of the creditors, whichever is less. So 100, for example, if there's a debenture holder, they have to collectively file. One single debenture holder will not be able to file the application unless they hold more than 10% of the debenture, total debenture holders. So either 100, they have to file collectively and jointly. Debenture holder, 100 of such debenture holders, or those debenture holder who holds at least 10% of the debentures, total number of debentures, whichever is less. The same principle also applied to the home buyers. Exactly the same principle, which is coming in the second provision. Provided further that financial creditor who are allowed to enter a real estate project. Now, what is real estate project? It is as defined under the RERA. RERA has defined what is a real estate project. So, those we are talking about the home buyers here. Application for initiating the corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project. Here we are talking of the same real estate project, not different account. Corporate debtor may have 10, 12 different projects going on simultaneously. But when we are talking about one real estate project, 10% of the same real estate project or 100 allottees of the same real estate project. We are not talking of overall number of the allottees. Okay, not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So these are the people who can file the application as financial creditor. As you must be aware that home buyers are now financial creditor under section 588F defined under the IBC 58F. Okay, under the IBC. So if your application is coming from the home buyers against the builder company, then this criteria is also required to be met in addition to the criteria which we have, like default of more than 1 crore, application should be complete in all respect, no disciplinary proceeding against IRP, no fraudulent intent. In addition to those, there is one more criteria they have to fulfill so far as the home buyers are concerned or class of creditors are concerned, that they should be at least 100 in numbers or 10% of the total number of creditors in that class. They should be representing or filing the application. CIRP by the operational creditor. All these I am doing in nutshell right now, because in detail probably tomorrow Dedeep will be handling this. So CIRP by the operational creditor, section 8 and 9. Notice by the operational creditor, on occurrence of the default, operational creditor shall deliver to the corporate debtor the following documents. What are the documents which are required to be given for operational creditors? Here, when we come to the financial creditor, no notice was required to be given. Financial creditor can simply file the application before the NCLT under section 7. But when it comes to the operational creditor, there is one more stage which operational creditor have to comply with, that is giving the notice under specific format, that is form 3, demand notice. So when it comes to the operational creditor, on occurrence of the default of more than 1 crore rupees, operational creditor shall deliver to the corporate debtor the following documents: one, demand notice in Form 3, or the copy of the invoice attached with the notice in Form 4. Either of these. At the registered office, by hand delivery, or by RPAD, or by speed post with acknowledgement due, or by email, service to the whole time director or designated partner or key managerial person, if any, of the corporate debtor. A copy of the demand notice or invoice demanding the payment is served by the operational creditor shall be filed with the IU, that is information utility. Corporate debtor shall within 10 days. Now see, demand notice is served by the operational creditor to the corporate debtor. Now what corporate debtor have to do? They have to within 10 days either dispute this demand notice or they have to make the payment. Now how can they dispute it? We'll see this. Corporate debtor shall within 10 days of receipt of the demand notice or copy of invoice bring to the notice of the operational creditor about the existence of the dispute, if any, or the record of the pendency of the suit or arbitration proceeding filed before the receipt of such notice, or invoice in relation to the dispute. So they will have to establish that there is already pending suit or litigation in some other court, or they have to establish a dispute within 10 days of the receiving the notice, or else they can make the payment of unpaid operational debt by sending the attested copy of the record of electronic transfer of unpaid amount from the bank account of the corporate debtor, or by sending the attested copy of the record that operational creditor has encashed a check issued by the corporate debtor. So they have to establish the proof of payment. They have to prove that the payment is made, which was in default otherwise. So that will be the role of corporate debtor once the notice is served. And that timeline is only 10 days. What happens after 10 days? If there is no such dispute or no such payment, then what happens? Then you can file, then operational creditor can file the application for CIRP. How that application is required to be filed, we will see this. After expiry of the 10 days from the date of delivery of notice or invoice demanding the payment, if operational creditor does not receive the payment from the corporate debtor or the notice of the dispute under section 8(2) of the operational creditor may file an application before the NCLT for initiating the corporate insolvency resolution process in Form 5. Again, this form is very clear. बहुत simple form है. जैसे financial creditor में it was Form 1, which is a simple format given in the IBBI adjudicating authority application to adjudicating authority regulations. Similarly, in Form 5 with the same regulations, this form is given, format is given to you. You just have to fill up that form properly, along with the fees of rupees 2,000 only, accompanied with the following documents. वहां पे 25,000 का फीस था. NCLT fees, if you see, for financial creditor it was 25,000. For operational creditor is only 2,000. Along with the following documents. What are those documents which are required to be annexed? Because these are very important. ये सारे documents लगाने तो ही आपका application complete बनी जाएगा. And if your application is incomplete, NCLT have right to reject that application. So you must annex all these documents, exhibit all these documents properly to your application. A copy of invoice demanding the payment or demand notice delivered to the operational creditor, delivered by the operational creditor to the corporate debtor. So demand notice जो भेजा उसका सीधा कॉपी लगा देना है. Second, affidavit to the effect that there is no notice given by the corporate debtor relating to the dispute of the unpaid operational debt. So once this demand notice was given, within 10 days, the other party, that is corporate debtor, was required to dispute the demand. If they have not given that, you have to file an affidavit that there is no dispute relating to the demand made. Thirdly, a copy of the bank certificate confirming that there is no payment of the unpaid operational debt by the corporate debtor, if available. Okay. And fourth, the copy of the record with information utility confirming that there is no payment of an unpaid operational debt by the corporate debtor, if available, and any other proof confirming there is no payment of the unpaid operational debt by the corporate debtor, or such other information such as आप कैसा अपना डेट कैसे प्रूव करोगे, वो सारा आपको यहाँ पे देना है. फॉर एग्जाम्पल कॉन्ट्रैक्ट for supply of any goods or services with the corporate debtor. As you know, operational creditor यानी goods or services supplier के हो सकते हैं. So contract for supply of goods or services with the corporate debtor. For example, कोई employee file करता है तो employment contract आएगा. Second, order of the court or tribunal that has adjudicated upon non-payment of the debt. So if you have found some order from any court, that can also be, for example, recovery suit file किया है, वहां से order मिल चुका है for you are a legitimate payment, your debt is genuine, then that should also be attached to it. Thirdly, financial account. What is financial account? Financial accounts means in your company, the ledger of the corporate debtor or the balance sheet of the corporate debtor. यहाँ पे आपका debt दिखाता हो, it's an acknowledgement of the debt, it's an admission of the debt. So all those documents which shows the entry, the ledger or the confirmation of accounts by the corporate debtor. कई बार corporate debtor year end को confirm करके देते that yes, I owe you X amount. So that would also an important evidence that he has admitted that debt. So you can attach that. Along with all these documents, you also have to file Form 2 of the proposed IRP. As I said, proposed IRP हर एक application में आपको Form 2 डालना है. You say, what is sir Form 2? यही सारे forms है, total 6 forms है यहाँ पे IBC में. First, Form number 1, when you are filing application with the by the financial creditor. Form 2 is the consent of the IRP. Form 3 is the demand notice. Form 4, again for the operational creditor, where you have to submit the invoices to the operational creditor, which just we saw. And Form 5 is this application which you have to file for the operational creditor. Form 6 जो है वो corporate applicant का next आएगा. So all these forms, these 6 forms are given in the IBBI adjudicating authority rules. You have to just fill up those forms. That's it. It's very simple to file this application. We just have to annex these documents properly. Apart from this act, as I said, everything you also have to see the CIRP regulation. So Rule 2B of the CIRP regulation also says that record or evidence of the transaction or debt or default by the operational creditors. Operational creditors shall, along with application under Section 9, furnish copies of the relevant extract of the GSTR 1 and GSTR Form GSTR 3B filed under GST law. यानी आपने जो इनवॉइसेस दिए क्या उसके ऊपर आपने जीएसटी भरा है कि नहीं भरा है? अगर नहीं भरा है हो सकता है इनवॉइसेस भी फेक हो. So that itself is an evidence to show your bona fide as an claimant or applicant that you paid proper GST and it's a legitimate tax invoice. And the copy of e-way bill wherever it is applicable, provided that the provision of this regulation shall not apply to the operational creditor who do not require registration of GST or to those goods or services which are not covered under any GST law. तो जहां पे GST नहीं लगता है वहां पे ये प्रोविजन भी नहीं लगेगा. Applicant shall serve by RPAD or by speed post or by hand or by electronic means, that is email, a copy of the application to the registered office of the corporate debtor and to the IBBI before it is filed with the NCLT. Same like financial creditor, it is required to be served in the same way. It is required to be served to the same people, registered office of the corporate debtor and with the IBBI before it is filed with the NCLT. The easiest way which we usually follow is email, even in addition to the hand delivery. Email से तो एक बार डाल ही देते हैं सारी application, सारी services, because it is one of the mode of service possible. So easiest way you send the email. Then you can send it by hand delivery or by RPAD if you want. NCLT shall, within 14 days of the receipt of the application by an order, admit the application or communicate such decision of the operational creditor and corporate debtor if the application is complete, there is no payment of the unpaid. Now what? NCLT will look into it while admitting the application. First, your application should be complete. Secondly, there is no payment of the unpaid operational debt which was demanded. Within 10 days, there was no payment. Third, the invoice and the demand notice of the corporate debtor has been delivered to the operational creditor properly. Fourth, that will be proved by your affidavit. Fourth, no notice of dispute has been received by the operational creditor, or there is no record of dispute in and IU, and there is no disciplinary proceeding pending before the IRP, or else if these things are there, NCLT will admit the application. If any of these things are missing, then NCLT may reject the application by giving 7 days notice to the applicant to rectify the defect in this application. CIRP shall commence from the date of admission of the application. So from the date when the application is admitted, there will be initiation of the CIRP that will be considered as insolvency commencement date. Why this insolvency commencement date every time I press upon is because from that date the role of IP will come. आगे जब हम CIRP process लेंगे हाथ में, वहां पे role of IP becomes very important once this litigation thing part is over. So we'll continue with that. Where the corporate applicant has committed a default. Now, this is the third type of application which is filed by the corporate applicant under section 10. A corporate applicant may file with NCLT application under form 6 for initiating CIRP against the corporate debtor application along with fees of rupees 25,000. When corporate applicant files, the fees is 25,000. When operational creditor files, 2,000 rupees fees only. And when it is filed by financial creditor, again 25,000. Along with the following documents, corporate applicant file करेगा तो क्या-क्या documents लगाने हैं वो form 6 के नीचे पूरा दिया हुआ है, पूरा checklist है वहाँ. So we can go through that checklist. But what the law says is information of its books of accounts and such other documents for the specified period. When we say such other documents for the specified period is given under form 6. पूरा checklist दिया हुआ है वहाँ. I'll take you to that also, how these forms are and how to fill up that form. Form 2 of the proposed IRP. So that is consent of the IRP, which we are supposed to make. The special resolution to be passed by the shareholders of the corporate debtor or the resolution passed by 3/4 majority of the total number of partners of the corporate debtor. Because when it comes to LLP, it is required to be passed by 3/4 majority of the total number of partners. Approving the filing of application. Since here the company itself is filing the application, it is required to be filed with by special resolution. The applicant shall serve the copy of the application to IBBI. Here no registered office because company खुद ही file कर रहा है. When company itself is filing the application, no point of serving any copy to the registered office because company itself is filing it. So a copy is required to be served to the IBBI by RPAD or by post or by hand delivery or by electronic means. Same thing. Before its filing with NCLT, NCLT shall within 14 days of receipt of the application by order either admit the application if it is complete and no disciplinary proceeding is pending against IRP, or else it will reject by giving 7 days notice to the applicant to rectify the application. CIRP is commenced from the date of admission. The same thing, very simple when it comes to the corporate applicant also. But the list entire is given in the IBBI's adjudicating authority regulation. So we'll see that list if the time permits. Otherwise, I'll go through the regulations. Now, what happens once this application is filed by financial creditor or by operational creditor or by corporate applicant? What are the steps involved? Practical aspects. हम लोग ये फाइल करेंगे उसके बाद आगे कैसे बढ़ेगा CIRP before admission, how the court process will move. So first thing is the drafting of requisite application, synopsis, वकालतनामा. ये सारी practical चीजें कहीं लिखी हुई नहीं है. It is not coming from any rules, regulation, law, except NCLT rules में आपको कुछ चीजें मिल जाएगी. But these are the practices of the NCLT. So how we draft application, क्या-क्या documents लगते हैं? Drafting of requisite application, synopsis, वकालतनामा, dates and events, memorandum of address, short index, long index, affidavit in support, docket, right? Application shall be, applicant shall also get the affidavit in support, notarized and stamped. Then carrying out the necessary administration work, just like how we file for any other application. High Court में file करते हो, civil court में file करते हो, यही सारी similar, बहुत similar process है. Carrying out the necessary administration work such as numbering, paging, writing, translation from any other language to English language, xeroxing, printing, scanning, etc. Then, because now things are virtual, so you will do the e-filing of the company petition or interlocutory application. If it is within the company petition, then you will say IA, IBC. So you'll file requisite e-filing and providing the requisite basic details about e-filing, details about the petitioner, details about the respondent, that is corporate debtor, details about the authorized representative of the advocate, uploading the petition or IA application, proof of service. Proof of service, as I said, is very important even before filing the application, because you have to upload it in the e-filing stage, etc. at the NCLT portal, and paying the necessary fees. कौन सी fees? वही 25,000, 2,000 जो हमने देखा वो same fees. If it is interlocutory application, the fees is only 1,000 rupees IA के लिए. And dealing with the scrutiny of the filings by NCLT and dealing with the administration department of the NCLT to remove the objections, if any. So what happens once you file this, you do the e-filing, the scrutiny takes place of all the documents, etc. And the administration department of the NCLT will take out the may have certain objection. You have to remove all those objections, if at all there is an objection raised by them. So same process how we have for any other court. Then getting an application, filing or lodging number. Next is submitting 2 sets of the petition or application to the NCLT and service of the physical copy of the application to the corporate debtor. So अब 2 सेट जो पिटिशन के या एप्लीकेशन के है वो एनसीएलटी में सबमिट करना है और एक आध कॉपी उसको सामने वाले को कॉर्पोरेट डेटर को देना है. Filing of the affidavit of service with the NCLT if required by the Honorable NCLT. Moving precipi to the NCLT for bringing the matter on the board. Appearing and getting the court notice issued to the corporate debtor if it is required. Filing of the wakalatnama and reply. Once this process is done, यहाँ तक applicant का पूरा process था. Applicant have to carry out this entire thing for filing the application, removing objection, getting uploaded, getting it on the board. बोर्ड पे आ गया, उसको सामने वाले को नोटिस भी कोर्ट में सर्व कर दिया, कोर्ट नोटिस इज सर्व टू द अदर साइड. Thereafter what? Thereafter the other party will come into picture, that is corporate debtor. They may dispute the default, and in that case the lawyer of the corporate debtor will file the wakalatnama. They will file the reply of the corporate debtor by the corporate debtor's advocates. Then once the reply is filed, what happens? The next is rejoinder, filing of the rejoinder. That is reply to the reply. The reply which is filed by the corporate debtor, that is reply को हम लोग schedule suit में written statement बोलते हैं, वही है यहाँ पे. Reply by the corporate debtor, and thereafter it comes to the rejoinder to the reply filed by the corporate debtor. So all this process, filing of the application, then reply, then rejoinder, and then appearing and arguing of the matter. In case there is any dispute, so both the parties will be given an opportunity of being heard. Both the parties will argue and put up their case before the NCLT, and then NCLT will decide the matter. But do remember, this is not the adjudicating authority. Essentially, this is not the long trial, evidences where evidences are taken, where trial is taken. This is a summary court. NCLT is a summary court. So you don't have the other practices which you have in civil court, like having a trial, affidavit of evidences, all those steps, framing of issues and all that thing. Here you simply have arguments and the court will decide. And once you have the argument, you will also file your written arguments if it is required. And then the NCLT will place your matter reserved for order. That is, they will reserve the matter for order after hearing both the parties. And then they will upload once the order is passed, they will upload it on the NCLT's website, NCLT's portal. Their order will be uploaded. So that is how the entire process flows, how application is required to be filed before the NCLT, how it processes in the NCLT, all these steps you have to follow. And then the NCLT passes the order. Once the NCLT order is passed, and if corporate debtor, and there is the initiation of the corporate insolvency resolution process, that is admission of the application, then the corporate debtor would like to appeal against the order passed. Then how the appeal lies? Appeal provision will discuss that where the appeal lies. Then it comes to section 61 and section 62. It says that notwithstanding anything contrary contained in the Companies Act 2013, any person aggrieved by the order of the adjudicating authority under this part may prefer an appeal to the National Company Law Appellate Tribunal, that is NCLT, within 30 days. Provided that NCLT may allow appeal to be filed after 30 days if it is satisfied that there is a sufficient cause for not filing appeal, but such period shall not exceed 15 days. So even NCLT has limited time to extend the timelines, maximum 15 days, not beyond that. So this appeal is required to be filed within 30 days, NCLT. An appeal against the order approving resolution plan. Now here, under section 61, if you see, various types of appeals are also mentioned. One is a normal appeal from the order of NCLT. Other is when you file appeal against the order approving the resolution plan. Another is appeal against the order of liquidation, appeal against the pre-packed insolvency. All these appeals are there. We will discuss that, which is given under section 61. So next, subsection 2 says that an appeal against the order approving resolution plan under section 31 may be filed on the following grounds, namely, approved resolution plan is in contravention of the provision of any law, or there has been a material irregularity in exercise of the power by the resolution professional during the CIRP, or the debt owned by the operational creditor of the corporate debtor have not been provided for in the resolution plan in the manner specified by IBPI. यानी कि ऑपरेशनल क्रेडिटर को जो मिनिमम मिलना चाहिए वो नहीं प्रोवाइड किया है resolution plan में. Then also you can file an appeal. CIRP cost has not been provided. As I said earlier, the CIRP cost is first in priority, so that will be paid first. अगर उसके बारे में provide ही नहीं किया है, you can file an appeal in the NCLT and NCLT. Similarly, resolution plan does not comply with the criteria specified by IP. These are the grounds on which the resolution plan can be challenged. An appeal against the liquidation order passed under section 33 or section 54. 33 is about the liquidation. Section 54L4, that is relating to prepacked insolvency resolution plan, or section 54N4, which is relating to termination of the prepacked insolvency, may be filed on the grounds of material irregularity or fraud committed in relation to such liquidation order, or appeal against the conversion from prepacked insolvency CIRP into CIRP. So those an appeal against order for initiating CIRP passed under section 5402 may be filed on the grounds of material irregularity or fraud committed in relation to such orders. These are various appeals which are filed in the NCLT within 30 days from the order of the NCLT. The next level is Supreme Court. If a party is aggrieved by the order of the NCLT, then it can go to the Supreme Court by filing an appeal within 45 days. That is given under section 62. Any person aggrieved by the order of the NCLT may file appeal to the Supreme Court on the question of law. It is important to know here that when you go to the Supreme Court, it will be mainly for the question of law only arising out of such order under the code within 45 days from the date of receipt of the order. The Supreme Court may, if it is satisfied that the person was prevented by sufficient cause from filing the appeal within 45 days, allow the appeal to be filed within further period not exceeding 15 days. So these are the main how appeal provisions lies, how the application is filed before the NCLT, and how the matter is taken at filings are done under the IBC. Now the next step is about the CIRP process. Once the application is admitted and the corporate insolvency resolution process has commenced, the role of IP comes into picture. The role as a lawyer comes to an end here, essentially. Thereafter, the lawyer will come into picture only when there is interlocutory applications are required to be filed. As I said, the complication arises in the CIRP process. There are various applications are filed depending upon the facts and circumstances of each case. For example, there is a non-cooperation as a management. So under section 19(2), there may be application for non-cooperation. Similarly, the CIRP process is a time-bound process which is required to be completed within 180 days. You may, if the process is not completed within 180 days, you may file the application for extension of time beyond 180 days. So with this, we just completed the regulatory part. Just to also share with you about the CIRP process, how it begins. Once this application is admitted by the once this application is admitted by the NCLT on the insolvency commencement date, the corporate insolvency resolution process shall commence, and the insolvency professional, as it was recommended as IRP in the application, shall be appointed as interim resolution professional. Why it is interim resolution professional? Because his appointment is only for 30 days. Beyond 30 days, it will be considered as resolution professional. He will be confirmed after 30 days by the committee of creditors. Now, this committee of creditors and all, entire process we'll discuss in next 10 minutes. So let's try and understand that process first. Once the IRP is appointed as an insolvency professional, what he will do? He will make a public announcement in 2 newspapers. In 2 newspapers, one in English, one in vernacular language. Within 3 days of his appointment as IRP or on the insolvency commencement date. Within 3 days, he will make a public announcement inviting claim of all the creditors of the corporate debtor. Any corporate debtor के जितने भी creditor है, financial creditor हो, operational creditor हो, कोई भी other creditors हो, कोई भी creditors है, they will invite the claims within next 14 days. Does it mean अगर 14 days में claim submit नहीं हुआ तो they lose the claim? Answer is no. They can still submit the claim up to 90 days. But this 14 days has significance because the COC will be decided based on what claims have come in the 14 days. So, IRP will make this public announcement within 3 days to invite the claims from all the claimants of the corporate debtor within 14 days. IRP has many other responsibilities, even though it is not specifically given in the law or IBC Act or regulations also. IRP will communicate with the regulatory authorities. IRP will communicate with each and every creditors of the company. IRP will debit freeze the bank account. IRP will open the website. IRP will upload the order on the MCA site, the order of the NCLT for initiating the CIRP. IRP will start its own website. Many things IRP will do simultaneously. IRP will take custody of the assets of the corporate debtor. But what is the most significant? Once the CIRP order is passed and IRP is appointed, once he invites the claim, simultaneously he will also do 2-3 very important things, which says once on insolvency commencement date, the moratorium shall apply. Moratorium shall apply means no suit or legal proceeding can be filed by or against the corporate debtor. So there will be like a stay on all the legal proceedings by or against the corporate debtors. No recovery proceedings can be made against the corporate debtor. Similarly, the management of affairs of the corporate debtor shall vest in the IRP, whereas the existing board of director shall remain suspended. जैसा ही CIRP order passed हुआ from the insolvency commencement date, the existing board of directors of the company becomes suspended, and the management of the affairs of the corporate debtor lies in the IRP. He becomes whole and soul of the company. All the directors are supposed to cooperate and support with the IRP in carrying out the CIRP. They will provide the requisite data, information, etc. to the insolvency professional. Similarly, all the employees of the corporate debtor, officers and employees of the corporate debtor shall be answerable to the IRP, shall be reporting to the IRP, not to the erstwhile board of directors. Similarly, the bank account or the bank managers or the bank or financial institution shall obey the instructions of the IRP. So IRP will do what IRP will do? They will immediately first go and debit freeze the bank account so that money is kept safe. So IRP will do all these activities once they have the management of affairs, once they have custody of the assets, they'll collect all the information from the existing board of directors or the existing management, all data, information. That is how they take custody of the assets. They will take custody. They may change the security guard, everything. Study they will take in their own manner in different depending upon the facts and circumstances of each case. But simultaneously, all these things will be going on. Similarly, once all this claim comes within 14 days, the IRP will examine and collate all these claims, and examine the claims. We will also verify the claim and prepare the list of creditors. So as I said, within 14 days, all the creditors will be submitting their claims. Financial creditor, operational creditor, other creditor, every creditors. But IRP will verify, collect these claims, examine those claims and verify those claims and prepare the list of creditors. He will verify the claim within a period of next 7 days. So after 14 days, next 7 days goes into that claim verification. Thereafter, in next 2 days, he will prepare the list of creditor where he will segregate the financial creditors, operational creditors, other creditors, those claims which are under dispute, those claims which are time barred, those claims admitted, those claims rejected, all these things he will make. And he will prepare the list of creditors, and he will also constitute something called as committee of creditors. What is committee of creditors? Committee of creditors are made of financial creditors. After he segregated financial creditors, operational creditors, other creditors, etc., he will prepare the committee of creditor and certify that based on the claims received in the initial 14 days, these are the people who are financial creditors, who are independent financial creditors, and they form part of the committee of creditors. If a financial creditors are not independent, for example, the promoter of the company himself has given loan to the company, they are not independent. For example, a relative of the promoter has given loan to the company, they are not independent. So if they are not independent financial creditor, it will not form part of the COC. So they will remain financial creditor. Okay. So that is how the constitution of COC will take place. And this certification shall be submitted, that is order certifying the constitution of the committee of creditor and the list of creditor shall be submitted by the IRP to the NCLT. So two things IRP will submit to NCLT. One is list of creditors, all the creditors who have submitted the claim in 14 days. Second, report certifying the COC. That will be done within next 2 days. And then IRP will issue the notice to all the stakeholders, essentially the committee of creditors, for holding the first meeting of the COC. First meeting of the COC notice will be given to the committee of creditors, to the corporate debtor ex-management, to the financial creditor who may be independent or not independent. They all will be given notice to attend the first meeting of the COC, and then within 5 days, this COC meeting will be held. So overall, the period of initial 30 days is over. First, 3 days public announcement, 14 days receiving of the claim. Within next 7 days, claim verification. Within next 2 days, preparation of the list of creditor and report certifying the COC. And then by giving 5 days notice, they will hold the first meeting of the COC. So that is how the timeline goes. In the first meeting of the COC, IRP shall transact certain business. Some of the important transactions are conversion of the IRP to RP or the appointment of the new RP. In the first COC meeting, either the IRP shall be appointed as resolution professional by the committee of creditors, or the committee of creditors may replace the resolution professional. So they will remove the existing IRP and they may appoint another insolvency professional as a resolution professional. Second, they'll appoint the registered valuer who will value the corporate debtors' assets, whatever assets that may be. Thirdly, how to carry out the CIRP. Just generally in the same COC meeting, the IRP shall also brief the COC members about the 30 days, what progress he has made and what is his observation in the company, any suspicious transaction he may have found. What is suspicious transaction? Preferential transactions, fraudulent transactions, extortionate transactions, all these undervalued transactions. So these are suspicious transactions as given under the IBC. So he will identify if there are any suspicious transactions which are found, and he will report it to the COC. And if required, forensic auditor may be appointed or forensic may be required. So he will create an opinion relating to that particular suspicious transaction. Similarly, he will prepare a brief note about the entire corporate debtor, how we have prospectus. Similarly, here he will prepare something called information memorandum. So information memorandum shall be prepared by him and it will present it to the COC. That will give the entire details about the company. And thereafter, the 90 days, he will also publish something called EOI, wherein he will invite all the, again in 2 newspapers, one in English, one in another vernacular language. He will invite bids from the resolution applicants, whosoever is interested in the company, to invest in the company. So he will invite investors who is interested in the company to take over this company. And IRP, that is what we call it as EOI for submission of the resolution plan. And thereafter, the IRP, whosoever is interested in the bid, will submit the resolution plan. There may be more than one bidders. They all are called resolution applicant. IRP will verify whether they are all independent people and they are fulfilling the criteria under section 29A for submission of the resolution plan. And if he is satisfied, he will place all the resolution applicant before the COC, and then COC will decide about the approval of the resolution plan. If they can approve the resolution plan, whatever the bid have come, if they can approve the resolution plan, they will approve the resolution plan, which will be then placed to the NCLT for approval, and NCLT will finally approve the resolution plan. So there is a 2 layers process here. After the resolution plan is approved by the COC, which is a commercial wisdom, it will be approved by the NCLT ultimately. And there are certain criteria which are given under section 31 and 32 about approval of the resolution plan, which is also to be observed by the IRP and by the COC. And if it is not approved, if any of the resolution plan is not approved by the COC, then IRP will apply for the liquidation order. This entire process is required to be completed within a period of 180 days. However, if it could not get completed within 180 days, it can get extended by another 90 days. So that extension application is filed by the advocate. That is by way of interlocutory application. Similarly, what other applications advocate would be filing? Maybe there is a non-cooperation by the management in providing the information and data. There also a lawyer can file application under section 19(2) of the IBC. Similarly, replacement of the IRP or RP, there also advocate can file application. Similarly, there are suspicious transaction under section 43, 45, 66. That is all preferential transaction, undervalue transaction, extortionate transaction, or fraudulent transaction. There also IRP will be filing through the lawyer only application for about the suspicious transaction. So all these things where lawyer's role is very important, another insolvency professional role is very important. And that is how the entire CIRP process goes. Because of the paucity of time, I cannot go into details of the CIRP process as such. I'm sure will be taken by some other faculty in detail. But with this, I think we can complete our session. If there is any query, any doubt, we can continue.
Thank you so much, sir, for this enlightening session. I would like to ask all the participants to kindly unmute themselves and ask your questions directly to the speaker.
Hi, sir. What is repacked CIRP?
Repacked CIRP is before going into CIRP, in advance only you have the resolution applicant who is ready to resolve that particular corporate insolvency resolution process. So it's slightly different from the CIRP, where you are looking for in normal CIRP, you invite the bid of the resolution applicant from various bidders who are interested or intending in the resolution. Whereas in prepacked insolvency, you already have the resolution applicant in place before even going into CIRP, before even filing the application for the CIRP. So pre-hand, before the company goes into this CIRP, CIRP process, there is a separate regulation which is very slightly different from this regulation, which is slightly fast track, and where the role of the COC is limited because the resolution applicant and everything is already decided. Resolution is decided. Things are very clear. So it is a pre-packed insolvency. Before going into CIRP itself, you have entire resolution applicant in place who is ready to settle the dues of the creditors. So mechanism is, of course, there is a separate regulation altogether for that pre-packed insolvency. So if you read in section 54 L to M, pura entire process is given in section 54. You can go through that. But it is well in advance, it is prepared. Yeah.
Sir, good evening, sir.
Good evening.
What is EOI, sir? What is EOI?
Expression of interest, sir.
Yes.
Expression of interest. Means
Hello?
EOI means we are inviting bids of the resolution applicants. That is expression of interest.
Hello. Hello. Good evening,
Yes.
sir.
Good evening, sir. Am I audible to you?
Yes, you are audible.
Yeah, hi. Sir, I am Advocate Prasenji. So I practice in both NCLT and NCLT New Delhi. So first of all, the session was quite good. And few queries, one related to avoidance transactions. So
Yes.
is it always necessary to give a forensic report analysis in an avoidance transaction? In an
No,
IAM?
it is not mandatory.
Sorry?
It is not. Actually, what happens, when IRP is appointed,
Yeah.
he will examine, first of all, when he collects all the data and information, he will examine with his own wisdom. Is there any prima facie suspicious transaction? Many times it is very evident from the balance sheet and very evident from the nature of transactions that are suspicious. For example, you find 80 or 90% of the debt which are inventory. Asset side, if you see 80%, 90% are intangible assets or inventories, which is not recoverable. Or inventories are coming to our the debt which is going to a group company, and the group company is not paying. So entire transaction, entire customer or debtor is only one group company of crores of 80 or 90% of assets. So depending upon facts of each case, IRP will decide that this is prima facie suspicious, and then he will recommend, if he found that it is suspicious, it is mandatory for the IRP to create the opinion whether there is any suspicious transaction. And if IRP creates an opinion that there is a suspicious transaction, then usually he will recommend it to carry out the forensic. Forensic is not otherwise mandatory.
So therefore,
depends upon the views of IRP or RP.
Therefore, recently the NCLAT in one of its order has said that forensic report and evidences are not a conclusive proof that there is an avoidance transaction.
Absolutely, absolutely.
So
because
the
even forensic
onus lies on the RP, right?
Right.
Right. Okay, sir. Thank
the
you.
first thing lies on the RP. RP will be the first person who will be deciding whether there is any suspicious transaction prima facie. If there is prima facie suspicious transaction, he will put that before the COC. That these are the things which I have found during my collection of the information and records. These are the things which are there. And COC will then look into it, and then he will recommend, in my opinion, there is a suspicious transaction. And if there is suspicious transaction, then COC will also say, okay, then you go ahead and do the forensic if the company have funds. Otherwise, COC, many times you are object to that, the company do not have funds, then forensic they may or may not allow. But in that case, even IRP will go to the NCLT and say that these are the things. I found it suspicious, I leave it on the direction of the NCLT then to carry out the forensic or not.
Okay, okay. And one last question connected to the same avoidance application. Say there are about say 10-15 group entities or more than that, say about 20-30. So can one file avoidance application in breaks and parts, or does one have to file only one application? Because time is
no, actually one application is sufficient. Recently there is an order on that you don't have to file any application in piecemeal for different suspicious transaction. Different application is not needed. You can file a single application where you can cover all those suspicious transaction in single order. Even if it is preferential transaction, which is different, fraudulent transaction, which is different, but you can cover everything in one application. And when you are talking about the group entities, there is something also called group insolvency. You also have to look into that angle. The group insolvency is required.
Okay, okay. And suppose if in the whole CIRP process is closed, now there is an SRA, successful resolution applicant, but the RP says that he seeks more time to carry out these investigations because the rules for avoidance transaction are directory, which the court adjudicating authority has also said. So in that scenario, what can be the possible complexity? One can be that SRA might back out later on because certain valuations are not clear of assets.
See, when resolution applicant is giving the resolution plan,
yeah,
they will verify, and it is presumed they will not back out for the very reason that if all the information has been properly provided to them and they know the risk based on the constructive notice of the risk involved, if the resolution plan is submitted, they'll not be allowed to back out. They were aware of it previously, and that is the reason, many times this question arises even about the claims. Many times the claim comes after approval of the resolution plan by the COC, but before
Exactly.
it is approved by the NCLT. And those claims which are not even looked into by the resolution applicant while giving the resolution plan. So that is the reason as a IRP we use the prudent method that first we go through the balance sheet, all the creditors of the balance sheet as per the books of accounts, and those claims which are coming from the books of accounts, we segregate them. These are the claimants or these are the creditors who are already there in the books of accounts. Those claims of the creditors who are there in the books of account, but they have not made any claims, we make a separate list that these creditors are appearing in the books of accounts, but they have not submitted the claim yet. And when we make it a part of the information memorandum, it is ultimately shared with the resolution applicants. So when resolution applicant is aware of this, these claims are still there and it can come in future. So contingency is there. Later on, he cannot back out on those claims. Same principle would lie even for contingencies of the other nature.
Okay, sir. Got it.
So far as you are making proper disclosure, there should not be issue. In fact, in one of the matter recently I was handling in Bangalore, there was entire asset, there was a contingency about the title of land. The entire asset was the only land, and the land itself there was a disputed one, and the issue about the titles were there. So the resolution applicant, while giving, they were very reluctant giving any valuation to that. They don't know whether there is a proper title or not.
Okay, sir.
It happens.
Thank you.
Good evening, sir.
Yes.
Hello.
Sir, the question is from the which date the 90 days duration for the submission of claim will be calculated? Like from the date of the admission?
Insolvency
itself?
commencement date. Yes, insolvency
Yes.
commencement
The
date.
order on which date the order came, right?
That's right.
Okay, thank you so much.
Hello.
And even after 90 days,
Hello.
if it is a claim of the home buyers, etc., they are still submitted. They can still be admitted and accepted even after 90 days.
Hello.
Up to the resolution plan is approved by the NCLT. There are many judgments.
Hello.
Yes, Vijay.
सर जैसे कंपनी को अगर लिक्विडेशन में चली गई है अगर तो और ऑपरेशनल क्रेडिटर ने भी क्लेम नहीं किया है तो क्या वो क्लेम कर सकते हैं क्या?
लिक्विडेशन स्टेज पे कर ही सकते हैं ना? Why not?
कर सकते हैं अभी?
Of course.
Okay.
It is still within the timelines of liquidation. You can submit your claims. Liquidation is not yet completed. Company is not yet dissolved.
Okay. मतलब अभी तो सर कहाँ कैसे एप्लीकेशन मूव करनी होती है उस केस में?
There are forms given under liquidation regulations. Specific forms are given for the operational creditors. If it is rejected by the liquidator for any ground, then you can move application to NCLT. For adjudication against
liquidation. और सर अगर लिस्ट ऑफ क्रेडिटर में अगर नाम नहीं आए तो उसके लिए क्या होता है मतलब सबमिट करने के लिए?
Again, you can file the application to the NCLT.
Okay.
See, there can be many complications related to one category, or your claims are submitted but not admitted by the IRP, or the claim is partially admitted by the IRP. These are all called as disputed claims. That whatever supporting you have submitted, IRP is not convinced with it, and therefore he has not fully admitted your claims. Either he has rejected your claim completely, or he has partially rejected your claim, and it remains under dispute. And therefore, you have to get it adjudicated through the adjudicating authority, that is NCLT, at CIRP stage. Okay. And even for the change of category, tomorrow you claimed under the financial creditor, they put you in the other creditor. Recently, one of my matters has happened where a claim was submitted in financial creditor, but the IRP admitted entire claim, but in a category of the other creditor. The category is changed, the priority will change automatically. Your entire rights goes away under IBC if you understand it properly. And therefore, we have to even get it adjudicated at NCLT level, even those claims. Even if your claim is fully admitted, but in different category. You have to move to NCLT and get it adjudicated.
Okay.
All those things will be happening. All those things will happen by moving the interlocutory application by paying the fees of only 1,000 rupees. And that application, there is no specific format as such. NCLT rules are there. There are certain days of drafting in NCLT rules which is given. You have to follow the same format from the NCLT rules. But otherwise, it is just like how any other application you move any other court, city civil court or the high court, same principles are there.
Okay. Thanks.
Hello. Sir, could you please explain about the Provincial Insolvency Act, sir? I mean, where that act is focusing on individual. 1920 Act. Hello.
About Provincial Insolvency Act.
Yes. Because
what exactly you want to do?
Under the Act, once a person is adjudged as an insolvent, can he show the same order for the future debts if he incurs and again he become insolvent?
No. Once he is insolvent up to that data. So it is. See, if you see the overall process, very similar to you. Only thing you have to move the application to High Court or District Court respectively.
Okay.
And you have to move that application where the creditors will be coming together and they will be before the court. There will be hearing before the court, wherein entire administrator, whosoever is appointed, will collect all the information and submit it to the court. Right now, it is a court process, right? Because individual insolvency under DRT is not yet implemented. Bankruptcy process is not yet implemented. I'm talking of the earlier law, which is right now going on. So there, you do make application to High Court or District Court, and there also the administrator appointed will collect all the information from the individual. They'll submit the report that these are the assets, these are the liability. The question answer shall take place in the court, and ultimately he will be adjudicated as an insolvent. But unless there is any fraud or something, there is no provision of jail and all.
I got it, sir. The gray area, I suspect that. What if I missed out some creditors in the insolvency petition? Later on, the creditors will approach the court and say, I have claims. But the person is already...
That is where intention becomes very important, whether there is any fraudulent intent. If there is no fraudulent intent, you can establish, then it's fine. They will amend it. They'll make an amendment to that. That's
Thank you, sir. Thank you.
Hello, sir. Good evening.
Yes.
Thank you for the session, sir.
This
is not this question related to something else. Like, see, we have e-codes for different states and different districts, right? मेरा क्वेश्चन है कि NCLT और NCLT के बारे में जितने भी केसेस है, तो हाउ कैन वी मॉनिटर देम, एंड अगर कोई कभी देखना है कुछ केस के बारे में इंफॉर्मेशन, डू वी हैव सेपरेट पोर्टल्स फॉर देम?
Which cases you are talking about?
NCLT, NCLT के बारे में जितने भी जो केसेस है, जो e-court ऐप जैसा.
As I said, NCLT cases against the company can be filed only at the place where the registered office is located, correct? We just discussed about the territorial jurisdiction. So you have to see the NCLT of that particular state where the registered office is located. There will be only one NCLT in that.
Okay, just universally access तो नहीं मिलेगा.
हाँ?
ऐसा universally तो नहीं पता नहीं चलेगा, like.
Universally नहीं पता. You have to find out where the company's registered office is located. You have to find out that respective NCLT, and then there is online portal where you can check whether there is any proceedings filed against that. NCLT का universal एक ही है, Supreme Court का एक ही है, so you don't have to worry about those things.
ठीक है सर. और second सर, जो corporate law, corporate lawyers को NCLT इसका career का prospects क्या है सर?
बहुत अच्छे हैं. अभी तो सबसे ज्यादा इतने तो केसेस हो रहे हैं. एक CIRP में कम से कम, if I am not wrong, एवरेज भी निकालोगे तो 8 से 10 आपको एप्लीकेशन मिल जाएगी. I am talking of big NCLTs, big CIRPs.
So LLM corporate and securities बंदों को थोड़ा ज्यादा स्कोप ज्यादा है, इसका मतलब.
इंसॉल्वेंसी में अभी काफी अच्छा स्कोप है. It is evolving law.
Okay.
And see, until our system comes to a proper mindset, अभी आज के दिन में fraudsters, insolvency issues, stress, ये सब है. जब तक ये सारी चीजें सेटल नहीं हो जाती, वो ये डाउन नहीं होने वाला. अभी भी एनपीए हो रहे हैं, अभी भी स्ट्रेस है, अभी बिकॉज ऑफ कोविड इंडिविजुअल स्ट्रेस भी काफी बढ़े हैं.
करेक्ट.
अभी तो खाली कॉर्पोरेट इंसॉल्वेंसी हुआ, अभी इंडिविजुअल का आएगा तो वो और काफी प्लेथरा ऑफ वर्क विल कम. lot of things are going on. हम लोग सो नहीं पाते, इतना काम आता है.
शुक्रिया सर, थैंक यू सो मच. एंड लास्टली नॉट द लिस्ट, ये पीपीटी आप शेयर करेंगे सर? ये आपकी
Yeah, I'll be
पर्सनल
able to
पीपीटी?
share.
या, थैंक यू सो मच.
It's
Thank
my
you for the
personal
session.
PPT, but I'll share. Don't worry.
And thank you for the session, sir.
Because whatever I've covered in section 7, 9, 10, this is a very unique thing. It's a combination of 3-4 laws. So that will be helping everyone to, file the application.
हाँ sir, this would be like a guiding star for us. I mean, आगे जाके पढ़ भी सके, reference कर सकते. We can come back to you.
Definitely, I'll share it.
Thank you so much. No problem. Thank you. Yeah. Thanks. Bye, sir.
Mr. Harshul Shah, sir, actually your class is very excellent and very crisp, sir. Thank you for. Will you please share this PPT, sir? Is it possible, sir? And your.
I'll definitely share, sir. I'll definitely share the PPT.
Yes, very nice class, sir. You are having. Thank you.
Thank you. Thank you very much.
Hello, sir. My question is with regards to debenture trustee you mentioned in the session. So could you just relate it with section 7 and give me an example so that I can understand it better?
Sure. See, debenture trustees are financial creditors. They are also lenders, right? They are creditors of the company, corporate debtor. And debenture trustees are large in number. Debenture holders are large in numbers. They may have only one debenture trustee for all the representing all the debenture holders. So when these debenture holders who are the creditors want to file this application, usually they will file it through debenture trustees. This application will be filed by at least collection of 100 debenture holders or 10% of the total number of debenture holders. That is how the criteria lies. Whichever is less, either 100 or 10% of the total number of debenture holders, whichever is less. They can jointly move the application to the NCLT, just like how home buyers move the application, just like how any deposit holders would. Same principle lies to all the 3 categories, all the class of creditors. They have to file a joint application. So they have to substance their whatever documents they have to provide for each of them. ये एप्लीकेशन छोटा नहीं बनता है. ऐसा नहीं हो सकता कि वी फाइल समझो एक डिबेंचर होल्डर का डिटेल दे दिया एंड देन वी लीव फ्रॉम द कोर्ट टू रिफर टू एंड रिलाई अपॉन द रेस्ट एज एंड व्हेन प्रोड्यूस्ड. ऐसा नहीं हो सकता. हियर यू हैव टू एस्टैब्लिश द क्लेम. तो सभी का अगर जॉइंट एप्लीकेशन है तो सबका वो इन्फॉर्मेशन डालना है. और ऐसा भी नहीं हो सकता कि जैसे हम लोग हाईकोर्ट में या सिटी सिविल कोर्ट में फाइल करते हैं, यहाँ पे सारे होल्डर्स ने सिग्नेचर ले लिए, कंसेंट ले लिया, ऑथोरिटी ले लिया और सिंगल लेटर में हो गया. यहाँ पे यू टू एस्टैब्लिश द क्लेम. तो सबके डेट जो है डिफॉल्ट है वो एस्टैब्लिश करने पड़ेंगे. तो उसके रिलेवेंट डॉक्यूमेंट सबके अटैच करने पड़ेंगे. Was it useful or should I explain more in detail? Anything else you want? Any other query?
Thank you so much, sir. We are at the verge of ending this session. So I would like to wrap up the session. I express my gratitude to Mr. Harshul Shah for this illuminating session. His profound insights have left us inspired and enlightened. We are profoundly grateful for his generosity in sharing his wisdom, which will undoubtedly guide our paths in legal endeavors. We are grateful for the depth of knowledge he shared with us today, and we look forward to applying these valuable insights in our own legal journeys. Thank you so much, sir, for taking out your valuable time and enlightening everyone with your insights. We are extremely honored to have you with us today.
Thank you, Akanksha.
Yeah, thank you so much, sir. Now, I also would like to thank all the participants for being cooperative during this session. We'll meet tomorrow at the same time. Thank you all for joining. Thank you so much, sir.
Thank you.